Good morning. Happy Wednesday. So, Chille DeCastro is once again at it. He's suing Kate Peters, Josh Abrams, and Lackluster for defamation, apparently, allegedly. I haven't looked at the complaint yet. Here's the way I assume it's going to go. He's going to plead poorly, have a 12b6 motion pending. He's going to amend his complaint. There's going to be another 12b6 motion to dismiss based on, I don't know, res judicata, maybe collateral estoppel, maybe statute of limitations issues, failure to actually properly plead anything. I don't know. All of his complaints have just been pure trash. He doesn't know the elements. He doesn't know how to plead the elements, et cetera, et cetera, et cetera. So I assume it's just going to be the exact same shit show that every other Chille DeCastro lawsuit has been. Every time he's filed a complaint, it's been shit. It's been pure garbage. Every time he's lost, at least that it's made it to an actual resolution. He's got a case in California State Court right now against Kate Peters and Blue Bacon, and he's getting his ass handed to him in that. There's been a whole bunch of sanctions, discovery sanctions, that have piled up against him. So he owes Blue Bacon a bunch of attorney's fees. I'm assuming, though, that Blue Bacon is quite in the hole on this whole thing, though. I'm sure this Southern California attorneys are fairly expensive, at least in my experience. And so I'm just going to guess that this Southern California attorney that Blue Bacon has hired has cost him an arm and a leg, like probably $20,000-$30,000 at this point. Easy $20,000-$30,000. So, it's just, I assume it's going to be the same Chille DeCastro thing, try to run up the opposing party's attorney fees as much as possible before the case gets dismissed, and then wash, rinse, and repeat later in a different jurisdiction. So it's not really very interesting. That's all I'm saying. Like, maybe this will get interesting. Maybe, so it'd be interesting. What I would like to see, and maybe this is stupid, but I'd like to see Peters, Abrams, and Lackluster hire the one attorney jointly that represented Abrams in the first federal lawsuit that Chille filed against Abrams. I would like to see that. That would be interesting. That attorney seemed to be reasonable. I bet his billing was reasonable, and his pleadings were reasonable. And by pooling their money, they're going to, by pooling the attorney fees, they're going to mitigate a lot of the actual harm that Chille tries to do with these things. That's what I would like to see. But pipe dream. I don't know if any of them get along. I don't really follow any of them. So I hope the best for Lackluster, Peters, and Abrams. I hope they do well, and I hope Chille loses this one quickly and efficiently, as opposed to slowly and ponderously, in which he normally does. Speaking of defamation, apparently, allegedly, I'm being told that in the phone call from jail that I was covering in my live stream, where I was slightly inebriated, further into the video, apparently Lane Myers makes some allegations about defamation. So if I understand this correctly, he is alleging that the statement that the victim got his wife fired, it's true, because if it wasn't true, the victim would sue him for defamation and get some sort of an injunction on the defamation about him saying this defamatory statement. And first, let me just say that, if the prosecutor finds out that he's doing these phone calls from jail again, talking about the case, talking about the victim, etc., I don't know that I actually said this in the live stream, because I was a little bit inebriated. But one crucial thing was that he's not supposed to be live streaming from jail. And you're going to say, well, he didn't live stream. He did a phone call from jail, and then it was recorded, and then it was played later. Well, that is not a substantive difference. The 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 purpose for the ban was to prevent him from making more videos talking about the victim and or things associated with the victim. And here he is saying that like she should have sued him for defamation, so that what he's saying is true. Blah, blah. Like I'm not saying that it's going to come back and bite him in the ass. But if the prosecutor finds out, it very well might come back to bite him in the ass. Like, these are the kinds of things he's not supposed to be doing. And by doing it on that fucking loser's channel, 77K subs, can't get any fucking views. By doing it on his channel, as opposed to the channels the prosecutor knows about, maybe he's thinking he's hiding it or whatever, but it's silly. He shouldn't be doing that. Also, I've had someone approach me and say that I should call in and do a debate with Lane Myers. Well, two things. Number one, I'm not going to be responsible for getting Lane in trouble for live streaming from jail or for making video content from jail. I'm not going to be involved in that. Not that I would get in trouble, but I don't want him to get in trouble. This might be hard for Lane Myers supporters to wrap their heads around, but I'm not actually against Lane Myers. Like, I think the things he does are wrong and illegal, morally wrong and illegal, but I'm not against him. Like, as a person, like, I don't want to see anybody go to jail. I don't want to see anybody go to prison, and I'm not going to assist someone in placing themselves further in prison. In addition, because anything he says can be used against him, as I have stressed in the past, I don't talk to anybody about their criminal actions. I've had the opportunity to talk to, what's that dumbass's name? Turtle Boy, about his criminal stuff. And I didn't do it. Why didn't I do it? Even though he wanted me to, because obviously he wants the attention. He's monetized. You know, whatever attention he can get is good for his channel, good for his brand. But I didn't do it because I am not going to assist him in fucking himself. I don't have any ill will towards him. I'm not like in his corner or against him. But one thing I'm never going to do is assist a criminal defendant in screwing themselves by getting them to say things that are incriminating in a interview, in a live stream, even a record. You know what I'm saying? Like, I'm not going to do it. It's like, ethically, I can't bring myself to do it. Morally, I can't bring myself to do it because I hate seeing people go to prison and seeing people go to jail. And so I'm not going to do anything that's going to exacerbate that process. So I'm not going to do any interviews with him. I mean, maybe when all of this is said and done, maybe I'll talk to him. I don't know. He doesn't have any knowledge or anything like that, so I don't know why I would, but you know, that's neither here nor there. We're getting a little bit off topic. The topic is defamation. And the issue is, here's why he's wrong. Defamation is either per se or per quad. There's two kinds of defamation. Well, you know, there's libel and slander, but we're talking about per se and per quad. Slander comes in per se and per quad. Libel comes in per se and per quad. So defamation generally, which is libel or slander, is per se or per quad. Per se means on its face, the harm is, you don't have to prove the harm. You don't have to show a receipt showing that you had these costs. You don't have to show a spreadsheet that you lost this much income. You don't have to do that. You can just get damages for pain and suffering and loss of consortium and emotional distress, things like that, right? So you don't have to prove the specials. You can just get the general damages. Per quad is you have to prove the specials. You have to prove the harm. The harm is what you can show the receipt for, or the spreadsheet showing how much income you lost because of the defamatory statement. That's the difference between per se and per quad. Per se, generally speaking, you know, I believe that Arizona has some sort of a list of things that are defamation per se, and I'm sure some of the things that are on that list are accusations that someone has a venereal disease. Accusations that someone has committed some sort of a heinous crime, like being a PDF file. Probably saying that a professional, like a lawyer, is bad at his job. That is probably defamation per se. Saying that a woman is unchaste, that she's not a virgin. She's a whore. Probably defamation per se. Per quad is different. Like, for example, posting a negative review on a roofer's website that they did a bad job on your roof. Or that they made some like critical error. Like, this roofer didn't even put down the paper underneath the shingles. I don't know. That might be defamation per quad because well, didn't put paper on. Like, what does that mean? Is that necessarily bad? I mean, does that roof style even require paper? Like, is it bad? No one knows. But so you'd have to prove to the court that, well, actually people saw this review and they interpreted it as being bad, and so here are my damages. You know, I lost all, like, I was making $20,000 a month doing roofs for people, and then after he put this review out, my income dropped to $7,000 a month, and so he owes me that kind of difference. That's your special damages. That's how you show special damages on that specific kind of defamation per quad case. So not only does it have to be false, but also it has to cause damages unless it's in a special category of per se. Saying that so-and-so got my wife fired is not per se. It's not defamation per se. So what she would have to do is she would have to prove that it cost her money. What money did it cost her? Huh? So that's something that she would have to prove that I don't know that she can. Because if she says, you saying this thing about me, well, first of all, she was working at one place before, she's working another place now. I mean, she's not going to be able to show loss of income like a roofer would, because, she's an employee. She's not she's not a contractor. But if she was, for example, going to a therapist, like, is she going to be able to prove that the cost of the therapy is related to the defamation, or is Lane going to be able to prove that it's more likely because of the harassment? So she has a proof issue for defamation because it's going to be per quad, and she has to show receipts for something. So that's a proof issue. So that is the biggest hurdle for her to get over, which is why would she even try at that point? The second issue is there's no money in it. There's no money in it. She's gonna have to get a lawyer. Her husband's a lawyer, but that doesn't mean he knows how to do civil lawsuits, defamation cases specifically. I don't know how to do tax law. I don't know how to do immigration law. I don't do those. I stumbled through one workers' comp case once, but I don't know how to do it. I don't take those cases anymore. I didn't take the case in the first place. Another attorney took it, and I got handed it. And so I had another attorney I could ask, but I don't know anything about it. So I'm not saying, I do most kinds of law, but there are things that I just don't know. Like, they're not tied to anything that I normally do, and I just don't know the stuff around them. Like, I don't know the rules. I don't know the regulations. I've never done it, So I don't do those. He might only do criminal law. He might not have any idea of how to do, like, Eline, for example. Eline does personal injury. He probably is pretty good at personal injury, or at least he's competent at it. He's probably competent at it. But he doesn't know shit about fuck for constitutional issues. Like, remember, like, he thought that there was no way you can enforce state law in a post office, and I showed repeated example after repeated example, and there's that one doofus back in like Delaware or Maryland or something like that who got popped in a VA for recording and tried to use Eline's argument, and nope, sorry, that particular VA is not exclusive jurisdiction. The state has jurisdiction to enforce their laws there, and so yeah, you're screwed. So Eline's pretty useless at anything outside of personal injury. I'd be okay saying, yeah, take his advice on personal injury. He probably knows what he's talking about. But outside of that, he doesn't know. Because he hasn't done it. He hasn't done it. You're going to say, well, John, you haven't done it either. Well, maybe I have, maybe you haven't. You don't know. But he hasn't. You could tell he hasn't. because he doesn't know what he's talking about. Anyway, I'm digressing. But the point was that it's going to be expensive for her to do this, because if she goes to an attorney, there's no attorney who's going to take it on contingency because he doesn't have any money. So there's going to be no actual recovery of monetary judgment. There's no dollars that are getting from him to her, right? Because he doesn't own a house, he doesn't have a job, he doesn't have any assets. Like, the dude's broke as a joke. He's smoked all of his money that he's received. Like, he's got nothing, right? He's got nothing that you can get. So an attorney's going to take it on hourly, and that's going to be expensive. So that's a problem. And then as far as like an injunction, injunctions on future speech are really problematic. Really problematic. The default position is that they're unconstitutional. Any restriction on future speech, the default position is that it's unconstitutional, and it's got to be very narrowly tailored, and there's got to be an overwhelming state interest in doing this. And I don't think a court is going to just generally say you can't say such and such generally in a defamation case, because if he can't say she got my wife fired, and then Lane Myers gets married, which would now make that statement much more likely to be true, because then he'd actually have a wife, number one. And then what happens in the future if, when Lane Myers is married, the victim gets his wife fired? Well, now there's this thing where he can't say it, right? There's this court order saying he can't say it. So very problematic. I mean, in theory, the court could narrowly tailor it enough that maybe it'll survive scrutiny, but I mean, it's just a huge ball of wax that's going to be expensive and next to impossible to prove. So, and it has nothing to do with the truth or falsity of it. So, because she's not a public figure, because she's not a limited public figure, because she's not a public official, well, she's a public employee. Yeah, but none of those were public figure or public official or limited public figure. Those are what it would be required where she would have to show that it was untrue. There's kind of a presumption that a lot of these things are untrue. And so your defense is that Lane Myers would have to prove it's true. That's a defense. It's an affirmative defense to say it's true. She doesn't have to prove it's false. She asserts it's false. That's a defamation. And then the defense is for him to prove it's true. If she's a public figure, then that would get twisted around, where she would have to prove that he acted with either knowing it was false or with reckless disregard to whether it was false or not. But because she's not a public figure, a public official, a public figure, or a limited public figure, the duty is on Lane Myers. There's no presumption. The duty's on Lane Myers that he has to prove as an affirmative defense it's true. So him saying that it's true because she hasn't filed defamation lawsuit is like backwards. If she filed a defamation lawsuit, he would still have to prove it's true. And if he can't prove it's true now without referring to a defamation lawsuit, what makes you think he'd be able to prove it's true with a defamation lawsuit inside the confines of the defamation lawsuit to a judge? Well, no, Your Honor. Here's my proof that what I said is true, because he doesn't actually have any proof. He has a coincidence that his girlfriend was allegedly fired, hours after he sent his voicemail. But what he can't prove is that the victim heard the voicemail before the girlfriend was fired, that the victim contacted the person who's responsible for the firing, that even if the victim contacted the person who was responsible for the firing, that the person who was responsible for the firing would have or would not have done the firing but for the call. You know what I'm saying? Like, he has no proof of any of that. It's all outside of the realm of his of the facts that he has firsthand knowledge of. And I don't even know that that his girlfriend has knowledge of any of those facts. I mean, she might know that she's fired, and she might have the grounds for which she was fired. But anyway, I've rambled on long enough. It's been a defamatory day. I actually have a defamation lawsuit going on right now. My client is suing their neighbor, who thankfully has $1 million policy on their house. Thankfully. Because their neighbor put out signs saying that my client was a PDF file and got on a bullhorn and was shouting around the neighborhood. And my client works in healthcare, and you know, it's really bad. It's really bad to have someone saying that you're a PDF file for no reason. And yeah, I'm just super glad I took the case on contingency, and I'm just super glad there's $1 million insurance policy on the house, and the insurer is covering him. Well, they've taken the case with a reservation of rights, but I mean, they already did their investigation. They wouldn't have taken the case if they didn't think that they'd have to pay. Anyway, I'm rambling now. Thanks for watching. Have a great day.